When officers betray their oath, the courtroom becomes the stage for their reckoning. Here are some evil cops who finally face the full force of justice, especially the last one, so make sure to watch until the end. But first, this officer believed he could manipulate the system, but was confronted by a judge who saw through his deceit.
12/18 to 70.
And that will make you how old?
52, sir.
And the last four digits, your social security number? Mr. Noel, Special Prosecutor Hurdle has charged you with 15 counts of criminal conduct. And I'll go through them. Count 1. Corrupt business influence is a level 5 felony. It would indicate that pursuant to Indiana Code 35-44-1.1-2-1, that on or about a period of time from November the 9th, 2018 and August the 16th, 2023 in Clark County, state of Indiana, you did knowingly or intentionally through a pattern of racketeering activity acquire or maintain, either directly or indirectly, an interest in or control of property or an enterprise contrary to the form of the statute in such case made and provided. Count 2, theft as a level 5 felony. You then personally sold said Hellcat for $83,000, $83,716. Count 4, theft is a level 6 felony under Indiana Code 35-43-4-2A.
Numerous charges were also brought against Jamie Knoll's daughter, Casey, and his wife, Misty. It is truly remarkable to see how the sheriff was able to engage in such corruption and yet maintained his position in the agency for such a long time.
On or about August the 16th, 2023, in Clark County, state of Indiana, you did knowingly or intentionally alter, damage, or remove any record, document, or thing with the intent to prevent it from being used, produced as evidence in any official proceeding or investigation, that being you factory reset your phone upon the arrival of the Indiana State Police on your property. You, in your capacity as Clark County Sheriff, a public servant, did knowingly or intentionally assign to Rodney Walker, an employee under your supervision, duties that were not related to the operation of the governmental agency that you serve, that being sheriff. Assigned Walker duties on your personal property, rental properties, father-in-law's property, pole barn, property of Utica Fire Department. Count 11. And count 15. Official misconduct is a level 6 felony. It would indicate that between November the 9th, 2018 and December the 31st, 2022 in Clark County, state of Indiana, you, a public servant, that being Sheriff of Clark County, knowingly or intentionally committed an offense in the performance of your official duties, that being goes to employment as Sheriff of Clark County relating to Brent Fisher. Mr. Knoll, the first 3 counts are level 5 felonies, which have a range of imprisonment from 1 year to 6 years, with the advisory sentence being 3 years and up to a $10,000 fine. Counts 4 through 15 are all level 6 felonies, which have a range of imprisonment of no time in jail if treated as a misdemeanor to 2.5 years at the Indiana Department of Corrections, with the advisory sentence being 1 year and up to a $10,000 fine. Do you understand what you've been charged with?
Yes, Your Honor.
Do you understand the potential penalties?
Yes, Your Honor.
The next question is usually, do you intend to hire a lawyer? You obviously have counsel seated with you. I need to tell you, you have a right to a speedy public trial by jury in this county. You have the right to face all witnesses against you, severe question and cross-examine these witnesses.
Jamie sat through the proceedings with a complete lack of guilt as the judge systematically read out the 15 counts against him during the hearings. The tension was high in the courtroom as the state attorney made a strong case for his detention without bond. Despite the gravity of the charges, the judge decided to grant bail. But little did he know that this would turn out to be a serious mistake.
His passport to you by noon tomorrow, and then you will surrender it to the court by 4 p.m. next Monday, because it's my understanding the court here is closed tomorrow.
Yes, sir.
He will surrender all firearms except one shotgun of his choice to Indiana State Police. Being from the country, or as Mr. Wilder said, Washington County, I keep my shotgun double-aught near me, along with my .45, but I think one shotgun for personal protection is appropriate for him to maintain. He will not leave the state of Indiana without permission of the court, and they'll post $75,000 in cash. Mr. Knoll, you wanted him released without posting any bond, but it's a unique case, and you don't like my decision, I'm happy for you to appeal it. It won't be the first time you've appealed me, and the Court of Appeals told you I was right, so I'm happy for you to accept that challenge if you so please. I'm not going to have you report in.
After delivering the announcements, the judge made one thing unmistakably clear, leaving no room for confusion or misunderstanding.
You keep one shotgun only. Try to deceive me, you will not like the consequences. Understand?
Yes, Your Honor.
Okay.
And then, Judge, the issue of return of all other items, see if we can just take up in another hearing.
Well, it wasn't set for today, so
No,
yeah, we'll deal with that at another time. I assume now that everything's going to be unsealed, there'll be a lot of new things brought before the court that
yes, sir.
we'll address in due time.
Thank you, Judge.
Anything else?
No, Your Honor.
Nothing else from us, Judge. Thank you.
All right, we'll be off record. Thank you all.
Although Jamie was first granted bail, however, his freedom was quite short-lived. When he violated the judge's order, police raided his residence in March and found a stash of hidden weapons. When the judge was called back for another court appearance, he was clearly outraged and did not hold back this time, delivering an uncompromising reprimand.
I told Mr. Knoll, don't do anything stupid. Do not try to deceive me, defy me. You will not like the consequences. Today is that day. You are not the law. You don't interpret the law. You don't enforce the law. You're not above the law. I find that you are in contempt of this court. Take him into custody. No, that's enough. I'll find you guys in contempt for disrupting the proceedings, and you'll be there right there with him.
Ironically, Jamie Knoll's appearance in A&E's 60 Days In, a series that exposes the inner workings of law enforcement, ended up on the wrong side of the court. During sentencing, the judge made an intentional point of mentioning his feature in the series, highlighting the sharp fall from grace of the former sheriff.
Now, what is an appropriate sanction? The question is, I can sentence him up to 180 days without a trial, or I can sentence him to a day, or I can release him. You know what I think the answer is? 60 days in. That's what I think the answer is today. Now, Mr. Wilder.
Yes, Your Honor.
Or Mr. Boyles, I apologize, Mr. Boyles, your lead. Before he is released, I'll take your suggestion. I want an independent individual to scour that household to determine that there's no further weapons. I find that Mr. Ertl's original argument that he was trying to make that I sustained, an officer of the law, every time I go into court, I hear, I didn't know it was there. I didn't know it was there. It really did. You've heard that a million times. You've heard it a million times, and yet you still take them into custody, would be my guess. Every officer in the world has heard, I didn't know it was there. It's my friends. I'm not buying it. It was your burden. It's your responsibility, and today the court will enforce that. Take him away.
Even though Jamie Knoll received a 60-day term, his legal issues are far from over. He is currently facing 31 felony charges, and the outcome of his trial might mean a long jail term. Knoll's once powerful position has collapsed into an abrupt fall from grace, and he may spend years behind bars. Well, you will be shocked to hear what this next former supervisor of Border Patrol was facing charges for.
I received a call of a female down. She was face down, lots of blood. No, she was brutally attacked.
On April 9th, 2018, Ronald Anthony Burgos Aviles, a former supervisor of the Border Patrol, went on trial for the shocking and brutal murders of Griselda Hernandez and their 1-year-old son, Dominic Alexander.
That morning, more or less around 11:30 a.m., I received a call of a female down by Bristol and Riverbank Road, which is located in Mines Road, with lacerations to her head. While en route to that call, my dispatchers informed me that she was possibly deceased.
Okay. And did you proceed to that area?
Yes, sir. Upon arrival, the ambulance, the City of Laredo paramedics, the ambulance was already parked outside. I parked and I walked down to the trail.
Okay. Did you come in contact with anybody when you got there?
Yes, while on my way down, 2 paramedics were on the way up, and I asked them more or less, where is everybody? They said, follow the dirt trail and you'll see the body and you see the USBP agents down there.
Okay. Did you come in contact with a BP agent by the name of Dennison?
Yes, sir.
More than 20 witnesses, including family members, law enforcement officers, forensic experts, and close friends. Officer Alberto Cortez Jr. took to the stand to describe the horrifying scene he received about a woman down with lacerations on her head.
This is where BP units were stationed. 4 to 5 United States Border Patrol agents were located here. And a motionless, lifeless female body was about right here. She was facing eastbound. And upon me being a police officer, secure the crime scene, to look for any evidence that includes anything out of the ordinary. As I began to canvass the crime scene, in better words, I was walking around this grassy on the edge. There was one USBP agent, Agent Dennison, already ahead of me. He was already south. I passed the female body. I did look at her. I observed she was barefooted. She was face down. Lots of blood. Can you hear me? Yes, lots of blood around her upper middle torso on the dirt. And continuing my path southbound, I saw blood drops on the dirt. At this time, Agent Dennison said out loud, I found another body.
Okay. Stop right there.
Okay.
The incident occurred not far from Father McNaboe Park's walking paths off Bristol Road and close to the banks of the Rio Grande. Officer Cortez Jr. described the grim scenes when he discovered the body of the woman lying barefoot and covered in blood.
Is this the type of blood that you saw?
That is correct, sir.
You also said that there was, and you didn't walk on the, where were you walking? Let me ask you that, actually.
On the grass, where the grass and the dirt meet, right on that
So you stayed on the
boundary.
edge of the
Yes.
path. You did not disturb the dirt path.
No, sir.
Were you the first officer that arrived?
Yes, that is correct.
You were the first official Laredo police officer to arrive,
Yes.
and this location falls within your jurisdiction.
No. Each officer is assigned a certain area. I got dispatched to be there.
No, but what I'm saying, that's within the city limits.
Oh, yes, that is correct. Yes.
Okay, so this is within the city limits.
Yes.
What county is this?
Webb County.
So the body's in the city of Laredo and Webb County.
Yes.
Cortez recalled getting an urgent call from another officer at the scene shortly after he ensured that the scene remained uncontaminated. To his shock, the officer had discovered something completely horrifying, intensifying the gravity of the situation.
What was your impression of what had happened?
Any prudent person will see a lifeless, motionless body to come to the conclusion that she was deceased.
But at that time, the opinion as to how she was deceased based on what you're seeing, what you're assessing, are you making an assessment?
No, she was brutally attacked.
You also testified that he said that there was a body.
That is correct.
Okay. What happens at that point? Or what do you do at that point?
At that point, he was ahead of me, southbound. When I heard him say, "I found another body," I walked towards his direction, to his location. He was no longer on the dirt path. He was in the brush. And when I arrived there at the brush with Agent Dennison, I observed a motionless little boy as well.
Officer Dennison discovered another body of a motionless little boy, who was later identified as Dominic. The officer described the heart-wrenching scene as he saw the lifeless body of a 1-year-old lying on the ground.
What you saw?
Of course. Little brown booties, little brown boy booties, blue jeans that were covered in blood, freshly haircut, and what caught more of my attention was the way the body was positioned. He was placed. He wasn't thrown. He was placed. It's as if someone had placed him down.
Did you see any injuries to the baby?
Yes, lots of blood around the neck area, and that came down. I said again, blood on the blue jeans as well.
Okay. And you recognize this?
Yes, now I remember the T-shirt. Yes, sir.
Did you see any other injuries on the baby? How close were you to the baby?
Standing right over the body.
How many injuries did you observe on the baby at that time?
I only observed one,
And that was to
the neck area.
The clothes worn by Dominic were presented to Cortez, who immediately recognized them as the same ones he was wearing the day of the terrible tragedy. It is truly heartbreaking to watch the realization weighing on the officer while the father of the baby doesn't get fazed.
Agent Dennison was in front of you this whole
Yes,
time?
he was with me. Yes, sir.
And you were with him when the shoe was found?
Yes, sir.
And what communication came over the radio that morning?
It was broadcasted. Possible suspect, Burgos. That was broadcasted over my P unit, portable unit.
What was your reaction at that time? But when you heard Burgos, what did that did it mean anything to you at all?
No, sir.
Did Dennison?
Dennison was in close proximity where he could hear the broadcast on my radio.
You have your radio.
Yes, sir.
The name Burgos comes out.
Yes, sir.
It means nothing to you.
No, sir.
Do you see a physical change in Agent Dennison?
Yes, sir.
To you, what do you see this physical change?
He was in shock.
Cortez also told the authorities that when he heard the conversation about Burgos being named as a suspect, Officer Dennison was in the area. His reaction, marked with a concerning familiarity, suggested that he was not shocked by the news, but rather that it felt all too normal in the circumstances they faced.
And you saw Mr. Burgos there at the scene as well?
I saw many of them, yes. But sitting here, I recognize him, yes.
And he appeared to be in shock as well as Agent Dennison, correct?
No,
That was not your impression?
no, sir.
So you're saying that he appeared to be normal to you?
Yes, sir.
All right. No further questions, Your Honor.
The officer disclosed a startling fact about Burgos. He showed no signs of shock or even remorse for what he did after he arrived on the scene. Now, this next case is the perfect example of how these cops abuse their powers.
He told me that it moved from the fast lane to the middle lane, to the slow lane, to the middle lane, to the slow lane. Is that correct?
That is correct, sir.
Okay. So, which was it?
On May 11th, 2017, a police corporal in the Fayette County town of Tyrone approached a parked pickup truck during a routine check. To his surprise, the driver behind the wheel was none other than State Senator Marty Harbin, known for his contentious support of the religious freedom measure from past years.
Our policy, over 30 days of expiration, we have to tow the vehicle.
You serious with me?
Yes, sir.
I'll call it. I won't call Eric Dial, but I'll call the rest of them. But I pay my bills. This will not go over well.
I can tell you, you can talk to everybody at the department. The car's going to be impounded.
The situation got rapidly out of hand, and when he was pulled over by another officer for driving with an expired tag. When he was told that his truck would be towed, he did not comply. The scenario became more intense because of his blatant attempt to use influence.
Because I'm going to take this, and I'm going to the state, and we're going to change the law.
You're not the only one this happens to. So,
Yeah,
I mean,
but I'm just saying
it's not
the
like
law,
we're picking on you.
The law's wrong in that respect,
Okay.
and I'm not mad at
Well, that's
you.
what I mean. We can't change the law. I mean,
Well, I can't.
But that's you.
Harbin was shocked to learn that the police officers are able to confiscate cars for anything as little as an expired tag. To modify what he perceived to be an unduly severe punishment for a relatively trivial error, Harbin had introduced a bill aimed at allowing drivers to drive away from expired tag offenses.
It was moving in the fast lane.
Okay. Was there any movement into other lanes?
Yes, sir.
Okay. Tell me about that.
The vehicle moved from the fast lane to the center lane at one point in time. And then from the center lane to the curb lane and then back to the fast lane. And then eventually exited the freeway, sir.
Okay. So when you were following the vehicle, it moved from the fast lane to the center lane to the curb lane, back to the center lane, back to the slow lane. Did I get that right?
Something like that, yes, sir.
Okay.
That'd be close.
Okay, so the vehicle changed lanes.
The vehicle did change lanes, yes,
Okay.
sir.
And then the vehicle exited the freeway.
That is correct, sir.
Okay. All right. Do you remember speaking with me during an interview a little while back?
Yes, sir, I do.
Okay. And you gave me honest answers during that interview?
To the best of my recollection, yes, sir.
Okay. Do you remember me asking you about the vehicle's movement during that interview?
No, sir, I do. I remember you asking the question, but I don't remember exact particulars, sir.
Okay.
During a tense moment in the courtroom, the officer was asked who had stopped the senator. As the lawyer pressed him, it became clear that the cop's story wasn't holding up.
Do you recall me asking, when you were following the vehicle, did it stay in the same lane the whole time?
I know you asked numerous questions. That may have been one of them, yes, sir.
Okay. Do you recall your response?
No, sir, I do not.
Okay. Permission of the court, Your Honor, I would like to play the portion of my interview with Sergeant Pavis where I asked him whether the vehicle, when he was following it, if it stayed the same lane the whole time.
And Mr. Payne, any objection?
No, Your Honor.
Okay. That portion of the tape, Mr. Moore.
And just going backwards a little bit. Okay. When you were following the pickup truck, did it stay in the same lane the whole time?
Yes, it did.
Okay.
When we got closer to
Okay. Did you hear that, Sergeant?
Yes, sir, I did.
Okay. So when I asked you, did the pickup truck stay in the same lane the whole time, your answer was, yes, it did.
That is correct. That is my answer.
The lawyer skillfully exposed the lies in the officer's testimony by playing a video of the cop's previous interview regarding the incident in court.
And just before I played that, when I was asking you about whether the pickup truck stayed in the same lane while you were following it, you told me that it moved from the fast lane to the middle lane, to the slow lane, to the middle lane, to the slow lane. Is that correct?
That is correct, sir.
Okay. So, which was it?
When I was behind the vehicle, I was in the fast lane the whole time. And at some point in time, as I just mentioned to you, he did move from lane to lane, sir.
Okay. So you don't find anything inconsistent with what you told me here in court and what we talked about?
I could see where you would see that as an inconsistency, yes, sir.
Okay.
The officer was left completely speechless as the lawyer skillfully proved him a liar in court. Each pointed question seemed to damage his credibility, and by the end, he had nothing to say in his defense. This next cop was not owned by a lawyer, but by a judge.
Then I want you taking him up on perjury.
Your Honor.
Will you take him up for perjury?
He admitted it was a mistake, Your Honor.
No, but he lied. He lied on a sworn
Absolutely
citation.
not, Your Honor, and that is...
46-year-old Lisette Gonzalez was charged with DUI. However, it was discovered during her trial that the arresting officer had not used a breathalyzer test. The judge was outraged by this wrongdoing and instantly reprimanded him.
I want to be enlightened.
It was a mistake, admittedly, by Michael Wagner.
I know.
He testified to that today.
He caused her to have her driver's license suspended for at least a few months for nothing. So are you going to null process that case, or am I going to get mad at you today?
Perhaps you can get mad at me, Your Honor, but at this point...
Why wouldn't you? Wait a minute. Did you hear the uncontroverted testimony of this officer?
Your Honor.
Then I want you taking him up on perjury.
Your Honor.
Will you take him up for perjury?
He admitted it was a mistake, Your Honor.
No, but he lied. He lied on a sworn
Absolutely
citation.
not, Your Honor, and that is not true.
I'm dismissing. I am dismissing this charge. No, I'm dismissing the charge. This whole case was fishy, and I have no idea how they... You know what?
Their address on file.
You know what?
The state intends to amend
I'm
the
granting.
charge and proceed on
I'm rescinding the sentence. I'm granting the JOA.
So you're granting it because you don't agree with the state's decision on
I'm
the
granting the JOA in fairness.
In fairness, because you don't like the state's decision today, Your Honor, on the case?
No, you're not. Now that I consider what Officer Wagner testified to and how many times he basically tripped over himself just to arrest this lady with no real probable cause. You're done. Motion, the JOA is granted.
And you're not going to provide a written order on that?
Nope. You want to appeal me? Appeal me.
Thank you, Your Honor.
The case should have never been done. Never.
Thank you for letting us know that, Your Honor.
As soon as things were made clear, the charge against Gonzalez was dropped and the cop was taught a lesson that he would never forget. The last officer might have a chance to redeem himself, but this next gentleman did not even show the slightest bit of remorse for his actions.
How are you? Well, I was doing just fine until just a minute ago. I already heard you say a cuss word once. So. What do your other signs say, sir? Sir, what do your other signs say? What am I doing? Okay, can I see your other signs? No, leave my feet away. Sir, we've got a complaint of you out here holding up profanities. Okay. Okay, if you don't let me look at your sign, I'll take you in custody for disorderly conduct. I'm not being disorderly. Okay. I'm not going to tell you again. All right? I don't consent to any searches or seizures. Okay. This is offensive to people that are driving by. And families that are driving by. Yes. Yes, it's disorderly conduct. What's the penal code? It's disorderly conduct. Can you read that to me? It's disorderly conduct.
The sergeant kicked the placards from Otto's hands and in mere seconds planned to arrest him. The auditor, realizing how devastating the situation is getting, decided to get on the ground to passively resist the cop.
Roll over. Since he's failing the ID, take him to jail for disorderly conduct. When we're here answering a complaint and you refuse to identify yourself, that is a crime. When you're displaying these signs and people are calling because it's offensive to them, that is another crime. So yes, you have committed a crime. You've committed two. You didn't warn me. We don't have to warn you. Ignorance of the law. I asked you politely to see your signs and you said no. I don't consent to any searches or seizures of my property or my person. I'm not going to take it.
If this illegal arrest wasn't enough, the officers continued to torment the poor auditor as they left his camera on the road.
I would like to see your supervisor right now before you assault me any further. I am being assaulted. I have not committed a crime. I have not committed a crime. Get up. I have not committed a crime. I can't get up. You're hurting me. You are hurting me. Then get up. I cannot get up. Then get up. I can't get up like this. They lift you up. I'm trying to get up. Matt, please get up. Help me to my knees. We already have one. Well, help me again. Now they'll lift you straight up. On your feet. Stand up. Okay, help me up. I have committed no crime. I have committed no crime whatsoever.
Soon after his arrest, Otto was charged with disorderly conduct, obscene language, and resisting arrest. Ultimately, the charges were dropped due to inconclusive evidence, and Otto filed a civil rights lawsuit against Sergeant Dial and the Royce City. The sergeant was then brought to a deposition where Otto's attorney wiped the floor with him.
As I explained earlier, one, it was an officer safety issue because I don't know what the signs are made out of or what they were. And they could be used as a weapon. And secondly, we were still investigating whether a crime had been committed. And he was unwilling to show us what the other two signs, or what the sign said, other than what we could see.
Did you believe that Mr. Knowles had an obligation to give you those signs?
What do you mean, an obligation?
Did you have the right to see those signs?
Well, it's part of our investigation.
Did Mr. Knowles have the right to refuse showing you the signs?
Anybody can refuse anything. Objection form.
Why did you hit the sign so hard?
With 11 years of experience in the police department, you would expect Sergeant Dial to appear a bit more confident and have ample knowledge of the law. However, contrary to this, he proved how inadequate he is in basic constitutional law.
I don't know what your definition of hard and soft is, and that was 5 years ago.
How do you define hard and soft? You can use your own definition, please.
In regards to what?
The level of force that you apply to the signs.
I mean, I don't know how I would describe hitting a sign soft or hard.
Why didn't you use less force when touching the signs?
I didn't know I used too much force.
Could you have used less force when touching the signs?
Objection. In regards to what? I mean, what was the amount of force that I used?
You said earlier that you conducted an investigation after you arrived on the scene that day with Knowles. What were the results of that investigation?
In regards to what?
Did you find anything during your investigation that caused you to arrest Knowles, that caused anyone to arrest Knowles?
Through our investigation, we determined that disorderly conduct had been committed.
How did disorderly conduct get committed?
Due to the verbiage that was on the signs, and we had received complaints.
The sergeant had violated Otto's First, Fourth, and 14th Amendment rights, and it turns out he also has no clue about disorderly conduct.
If you received the same complaints, and those signs had said something different, would Knowles have been arrested?
The same complaints in what? Because the complaint we had was, it was vulgar and offensive.
What I'm asking you is, if the complaints were the same, but the contents of the signs were different, would Knowles have been arrested?
Objection form.
What if the sign said Blue Lives Matter?
How is Blue Lives? There's nothing vulgar about Blue Lives Matter. There's no profanity in Blue Lives Matter.
Are you saying that if the sign said Blue Lives Matter, Knowles would not have been arrested?
I'm telling you that based on the complaints that we received that day, a guy telling me that he was offended by the profanity and vulgar that was being used in the signs.
Objection, non-responsive.
Dial refused to cite any law that had been broken that day and claimed to have made the arrest just because someone was hurt with what the placard had on them. It appears he really needs to read a book or two on the Constitution.
The complaints were the same, but the sign said Blue Lives Matter. Would Knowles have been arrested that day?
Objection, fam. There's no vulgar or profanity in in the verb or term, the verbiage or term Blue Lives Matter.
Do you think anyone that says a bad word publicly should be arrested?
No.
Why not?
Did someone complain on them, or are they just out there just throwing a fit? No complaints. I mean, there's several reasons why we would not arrest someone. I mean, if nobody finds it offensive, then disorderly conduct's not met.
So if the language on the signs had not offended someone, Knowles would have been arrested, or would he not have been arrested?
So you're telling me we didn't receive any calls and nobody complained to us? Would we have arrested Knowles that day?
Correct.
No, we wouldn't not have.
The attorney was doing a fascinating job holding the sergeant accountable, but the best part of the deposition was yet to come.
What specifically did Clark say to you about Knowles' prior disorderly conduct?
He was explaining it to Knowles that as I'm walking up, he's explaining it to him that, look, I've already heard you out here cussing at people.
So he was talking to Knowles, not you?
That is correct.
Did any motorists complain about the prior alleged profanities that Knowles said before you arrived?
Well, the one gentleman told me about the signs, and regarding what the people on 911 called in about, I do not recall that.
If anyone complained about verbal language and you didn't hear any allegedly profane verbal language from Knowles at the scene?
I did not hear it, but I heard Clark explaining to Knowles that he has already witnessed it or observed it himself.
Do you know one word of profanity that Knowles said?
No, I do not.
And you are not aware of any person that was offended by what Knowles said?
As the sergeant himself claimed that the arrest was made due to the contents of the placard, the attorney was ready with some even better questions regarding that which would silence the corrupt cop.
Were you offended by the contents of his signs?
No.
Why did you think they were offensive?
I didn't think they were offensive.
So why did you arrest them?
He was arrested. He was arrested because people had either called 911 or flagged us down about a gentleman that had offensive signs, and obviously Clark observed him using offensive language while he was there.
If Knowles said fuck the draft, would you have arrested him?
Objection. Directly to me or to who?
To anyone.
If they were offended about it, yes.
So are you saying that if anyone said anything offensive to anyone, you would arrest them?
I mean, I don't think certain terms, just because you're offended by them, does not constitute that. But when you have vulgarities or profanities in there.
The sergeant kept stumbling, making blunder after blunder, and the attorney was closing in on the core issue, First Amendment right. Clearly, this would be the final blow, completely dismantling the sergeant's shaky defense.
So you would arrest somebody if a citizen complained about vulgarities?
Objection. So a citizen made the police department or dispatch aware that they had used profanities and vulgarities and were...
Have you arrested more than 5 people in your career?
I believe that would be an accurate statement.
Have you observed more than 10 arrests in your career?
I'd probably say I have observed more than 10 arrests in my career.
Have you observed more than 25?
That I don't know.
Have you observed more than 30 arrests in your career?
I don't know.
Do you remember any specific details about your training regarding First Amendment rights?
No, I do not.
Are you saying that you don't remember one word from your training regarding First Amendment rights?
Objection. That is correct.
It is shocking that a 10-year police veteran didn't have any clue about the First Amendment. This poses a huge question to the entire law enforcement community. What kind of officers are being produced?
We went over the elements of the Constitution, and I believe the First Amendment is part of the Constitution.
But specifically the First Amendment, you don't remember?
Correct.
Do you remember how long you spent studying constitutional rights?
No, I do not.
Have you had any training related to constitutional rights since you became an officer?
I do not recall.
What topics have you been trained on since you became an officer?
I don't recall all of them.
Name one.
Accident investigation.
Anything else?
Well, I'm sure there's others.
Where did you receive the training regarding constitutional rights in 2007?
As when I was in the police academy, is that what you're referring to?
I'm referring to the training that you refer to, that you received in 2007 regarding First Amendment rights.
The Collin County College Police Academy.
And who trained you in constitutional rights?
Could not tell you.
Because you don't remember?
You're asking for the instructor's name? No, I do not remember the instructor's name.
The lack of IQ in this officer is clearly shocking for someone holding such a high position.
Do you remember anything about the protections provided to citizens by the First Amendment?
No, I do not.
Are you aware that the First Amendment gives citizens what's known as the freedom of speech? Have you heard of the freedom of speech?
I have.
What do you think that means?
Interpretations are a dime a dozen. But basically, someone can speak freely.
Does the First Amendment protect a person from being arrested because of what they say?
Objection form calls for legal conclusion.
Do I answer it?
Answer.
I think at times it may.
Has the police department provided you with any subsequent training on constitutional rights since you've been an active officer?
I do not recall.
Have you received any training, guidance, or instruction regarding First Amendment rights while you've been a police officer?
Objection form.
In the police academy, I know we went over the constitutional rights.
But anything since then?
I do not recall.
Well, this is what happens when you haven't been given any class or training on the First Amendment and the Constitution. Soon after this deposition, the city decided to grant Otto close to $25,000 to settle the lawsuit. Despite the sergeant's lack of knowledge, he was subjected to no disciplinary action, but was instead promoted to lieutenant. Well, the actions of this next cop will make Sergeant Dial seem like an angel in comparison.
Today is that day. You are not the law. You don't interpret the law. You don't enforce the law. You're not above the law.
In 2023, a former Clark County sheriff who oversaw the police and fire department was accused of stealing over $5 million from taxpayers' money and using that money to build a mansion, buy a Cessna airplane, and luxury car. As a result, he was charged with 25 felonies, and that's when the court proceeding started with Judge Larry Medlock.
Count 2, theft as a level 5 felony. It would indicate that pursuant to Indiana Code 35-44.1, you then personally sold said Hellcat for $83,000, $83,716. Count 4, theft is a level 6 felony under Indiana Code 35-43-4-2A. First 3 counts are level 5 felonies, which have a range of imprisonment from 1 year to 6 years, with the advisory sentence being 3 years and up to a $10,000 fine. Counts 4 through 15 are all level 6 felonies, which have a range of imprisonment of no time in jail, treated as a misdemeanor, to 2.5 years at the Indiana Department of Corrections, with the advisory sentence being 1 year and up to a $10,000 fine.
Jamie sat through the initial court proceedings as the judge read aloud the charges against him. The sheriff displayed no remorse throughout it all, maintaining a cold, expressionless demeanor.
And then you will surrender it to the court by 4 p.m. next Monday, because it's my understanding the court here is closed tomorrow.
Yes, sir.
He will surrender all firearms except one shotgun of his choice to Indiana State Police. Being from the country, or as Mr. Wilder said, Washington County, I keep my shotgun with double lock near me, along with my .45, but I think one shotgun for personal protection is appropriate for him to maintain. He will not leave the state of Indiana without permission of the court, and he'll post $75,000 in cash. Mr. Knoll, Mr. Wilder, I know you wanted him released without posting any bond, but it's a unique case, and if you don't like my decision, I'm happy for you to appeal it. It won't be the first time you've appealed me, and the Court of Appeals told you I was right, so I'm happy for you to accept that challenge if you're so pleased. I'm not going to have you report in.
Judge Medlock was fairly calm about the case, but made one thing very clear. Jamie would have no weapon except one shotgun.
You keep one shotgun only. Try to deceive me, you will not like the consequences. Understand?
Yes, Your Honor.
Okay.
And then, Judge, the issue of return of all other items, see if we can just take them in another hearing.
Well, it wasn't set for today, so
No,
yeah, we'll deal with that at another time. I assume now that everything's going to be unsealed, there'll be a lot of new things brought before the court that
yes, sir.
we'll address in due time.
Thank you, Judge.
Anything else?
No, Your Honor. Nothing else from us, Judge. Thank you.
All right, we'll be off record. Thank you all.
The corrupt sergeant had a habit of breaking the law, and he once again ignored the judge's command and was found to have multiple weapons in his home during a police raid. His bail was annulled, and he was quickly called to court again.
I told Mr. Knoll, don't do anything stupid. Do not try to deceive me, defy me. You will not like the consequences. Today is that day. You are not the law. You don't interpret the law. You don't enforce the law. You're not above the law. I find that you are in contempt of this court. Take him into custody. No, that's enough. I'll find you guys in contempt for disrupting the proceedings, and you'll be right there with him.
The judge didn't spare him this time and made sure to teach him a lesson by taunting him about his appearance in a TV show once named 60 Days In.
Now, what is an appropriate sanction? The question is, I can sentence him up to 180 days without a trial, or I can sentence him to a day, or I can release him. You know what I think the answer is? 60 days in. That's what I think the answer is today. Now, Mr. Wilder.
Mr. Honor.
Oh, Mr. Boyles, I apologize, Mr. Boyles, you're me. Before he is released, I'll take your suggestion. I want an independent individual to scour that household to determine that there's no further weapons. I find it, Mr. Hurdle's original argument that he was trying to make that I sustained, an officer of the law, every time I go into court, I hear, I didn't know it was there. I didn't know it was there. I really didn't. You've heard that a million times. You've heard it a million times, and yet you still take them into custody, would be my guess. Every officer in the world has heard, I didn't know it was there. It's my friends. I'm not buying it. It's your burden. It's your responsibility. And today, the court will enforce that. Thank you.
He was sentenced to 60 days in prison and was charged with 31 felonies. In August 2024, Knoll shamelessly pleaded guilty to 27 of the 31 felony charges against him.
Here it is. Defendant's Exhibit A?
Yes, Your Honor.
That's acceptable. Cross-examination, Mr. Hurdle.
Mr. Tidman, I guess maybe I don't fully understand, or maybe in Ripley County we use the IRS for something different each and every time, no matter what's the charge.
No, sir.
Okay, because that's what I got.
Judge, could he answer? He wasn't finished. He asked a question. Could he answer?
Is that an objection?
It is an objection. He cut the witness off and he wasn't finished answering.
Response, Mr. Hurdle?
I'll withdraw the question.
Thank you.
You may.
So all due respect, I'll repeat the question, Mr. Tidman. Is it your testimony today that if someone scores a 0 on the IRS, the court should just release them on their own recognizance?
No, sir. That decision is up to the judge. I can only simply make an IRAS recommendation and the supervision level recommendation.
Okay. And so you're not saying bond should be 1,000, 5,000, 10,000. You're talking about once bond potentially.
Knoll faces almost 15 years of imprisonment as part of this plea deal, and shortly his sentence will be announced, serving as a reminder for police officers to never steal taxpayers' money. These cases revealed jaw-dropping moments where officers, convinced they could bend the rules, met justice head-on. If this video had you on the edge of your seat, give us a like, subscribe, and drop your thoughts in the comments. But remember, justice doesn't always play out in the courtroom. Here is a fearless citizen who delivered a humbling lesson to an out-of-control cop. No judge needed. Check it out right here.